Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to our latest Private Clients podcast, Trust Matters, where we'll be talking about trusts in Australia. Just to give a little bit of backdrop to this circumstance, there's about $3.5 trillion of wealth that's expected to pass between generations in the next 10 to 20 years. And of that, trusts are a very significant part. So getting a really good understanding of trusts, given their complexity, really helps clients and advisors avoid a lot of the issues that we see. Being one of Australia's largest private client practices, and certainly the largest in a legal perspective, at Hall and Wilcox, we get to see a lot of these issues that come up. And part of what we wanted to talk through in this series was really some practicalities that we're seeing with our clients and with our circumstances, and really help the listeners out there understand what some of those issues are, and then really hopefully get in place proper processes and practices to avoid a lot of those issues that we do see. My name is William Moore. I head up the private clients team at Hall and Wilcox. And on our podcast journey, I'll be joined by my colleagues McLean Edinger, who heads up our estate disputes team in the private clients practice. He's a partner in our Perth office, and also by David Dickens, who's a partner in our dispute resolution team, and he's based in the Melbourne office. In terms of our series, what we'll be looking at is a number of practical considerations. Those include variations, exercise of trustee discretion, beneficiaries in their rights to information, and also a more problematic one that we're seeing more frequently, unfortunately, and that's dealing with lost trust deeds and what you can do. So in this particular podcast, which is the first of our series, myself and my colleague McLean Edinger will be talking about one of the most common aspects that we deal with trusts, which is trust variations.
I will. Very nice to be here, and thanks for having me on the podcast. Look, obviously the key thing with this topic is to start with the actual trust deed itself. You've obviously seen a lot of trust deeds in your time. What impact does that have on this issue?
It's a good question, and often it's the source of a lot of issues that we see with variation powers, is that when you're talking about varying a trust or amending a trust, the first and the most important aspect of that is actually looking at the terms of the trust deed. And having looked at thousands and thousands of trust deeds over many, many years, one thing that becomes very, very apparent is that not all trust deeds are created equally. You have good ones and you have bad ones, and you have some that sort of sit in the middle. And when we are looking at varying trust deeds, it becomes really, really important to look at the specific power that allows us to actually make that variation or make that amendment, and then consider whether it actually allows us to do what we want to do. And when we say do what we want to do, most of the times when we're varying a trust deed, it's really because of a specific reason. For example, it might be a bank requires some additional powers to be inserted for the trustee for borrowing purposes or to give guarantees. It might be because the trustee and their accountants or their tax advisors want some specific powers to assist with determining what income is or streaming particular types of income. It could be because we've had a expansion in the family, so we want to add some beneficiaries, or we might have had a bad Christmas, for example, and we want to cut some beneficiaries out. Now, they all have different considerations, and they have different points to look at, and that then brings us back to the variation power itself. So when we're looking at those deeds, we have broader powers and we have narrower powers, and sometimes we have no power at all. Perhaps just to help that, if we look at the variation power itself, if we think about a broad power, it might be something that says that the trustee can vary all the terms, powers and provisions of a trust deed. If you then compare that to a variation power that says the trustee, with the consent of the guardian, can vary the trusts hereinbefore of the trust. That's a much more limited type of variation power, McLean, and that's often one that brings a lot of people undone because they think that they can do anything, but they can't in reality.
Well, and that particular clause there, I think a lot of the old trust deeds that we saw before there was sort of a wave of case law in sort of after 2010 That was the standard wording in that clause, and there didn't actually appear to be sort of any advice provided as to what effect that could have or how it could limit the powers to vary. And it was only before it actually was dealt with by a dispute between a family, and it was challenged before a judge as to actually, if you read the words on the page, how that can restrict the ability of the trustee to vary the trust deed. And since then, we've obviously seen a lot of changes in terms of the way these trust deeds are being drafted now, haven't we?
That's right. I mean, when you think about that particular wording, trusts hereinbefore, for example, a lot of people took the view before those cases were decided that it allows you to vary any of the provisions of the trust. When those cases were actually handed down, what they made very clear was that that only allowed for variations to the trust component of a trust deed, which is not the whole of the trust deed. And often people were getting caught out because they had relied on that to change succession in particular, so to look at appointors or guardians. The other one that comes from that as well is that if you do actually need to get the consent of a particular person, such as a guardian or an appointor or a settlor in some occasions, if you don't get that consent, what you propose to do to vary the terms of the trust deed will fail, because you're not actually acting in a proper manner. You're not exercising that power properly because you haven't got that consent in the first place.
And the reference to hereinbefore, effectively what it meant was everything after that point couldn't actually be varied. And the problem is that a lot of the key office holders, including the beneficiaries of the trust, were listed in the schedule of the trust deed, which came after the variation clause. So it sounds very simplistic, but that's actually what the court found, and that's what has led to a lot of changes to the way that we and other practitioners in this area have had to draft the trust deeds. So on that note, there's obviously been some recent case law that's come out, but sort of what can go wrong if a party purports to vary the trust in a way that's found to be contrary to the variation powers in the trust deed?
A lot can go wrong is the short answer to that question. And often it's not just the variation that becomes invalid, it's the things that flow on from the variation. So a classic case, and I touched on it before, was if we look at the succession of control of a trust. So when we think about the control of a trust, your day-to-day decision making is made by the trustee, which is often a company with shareholders and directors. But then you also have other roles such as an appointor, whose consent is often required to do certain things or to remove and appoint the trustee. And then in a number of older trustees, you have a guardian, and they're almost like the protector, that the trustee can't do certain things without getting the consent of the guardian. When a lot of these trustees were set up, we're talking about the 1970s, the 1980s, where we're now starting to see those people who were at that first generation losing capacity, dying, and this succession piece is becoming very important. So a lot of people will use a variation power to say, if mum and dad, for example, were the appointors, we are then going to succeed that appointor role to their children. But the issue that you face if it's a trust hereinbefore, for example, is it doesn't necessarily permit you to do that. So taking that closer look, making sure it does give you that power to do it before you do it, gives you the confidence that you can actually succeed that control to the next generation. Because if you don't get that right, you end up in a situation, and there's been cases such as McCanty, there's been cases such as Jenkins and Ellett, there's been more recent case of Rioes, which is a Victorian case, where attempts were made to deal with the appointor provision or the guardian provision. And what the judges essentially said was the variation power wasn't that broad. It was actually quite narrow, and it was quite limited to just looking at the trusts. And because of that, those attempts to deal with the succession failed, and it often resulted in a situation where someone came to control the trust that wasn't intended to control the trust. And again, because these are discretionary trusts, that can cause quite a big problem.
Yeah, I was involved in a case recently where our client had been appointed trustee for some 15 years, and in fact, in the course of a dispute brought by his sister, one of the beneficiaries of the trust, it became apparent to us that a deed of variation that was done some 15 years prior that appointed our client or allowed our client to be appointed trustee, despite the fact he was also a beneficiary of the trust, hadn't been done in accordance with the variation powers in the trust deed. And it sort of led to us having to advise our client that if this goes to trial and a judge gets their eye on this, there's effectively potentially going to be a finding that you've been acting as what they call a trustee de son tort, for 14 or 15 years, and there'd been millions of dollars of distributions made in that time, which then effectively means you've got to try to claw them back. There's significant tax implications, and for that family, it would have put their wealth in jeopardy because the beneficiaries have spent the distributions. So it can cause a huge amount of issues.
And that's a good practical example, because when you think about the flow-on effects of that, when that trust controls the family wealth and you've got that potential jeopardy where something has been done that's not correct, and then that flow-on effect where you might potentially have 15 years of invalid distributions. You then have to go back and amend assessments. You then might have default distributions, which send the income to someone else who's not intended to receive it. It has a significant impact and potentially a very, very detrimental impact on that family. And it really goes back to the point of, I think sometimes there's a hesitation to look at these things properly and to get them done properly. But if it's not done properly, the consequences that can spin off can be astronomical sometimes.
Well, and I think also there's been a lot of trusts that have been varied well before these more recent cases that have highlighted the issues in terms of interpreting certain variation clauses. So I think, and they could have been, those deeds of variation could have been done 10 or 20 years ago, and there would have been significant long-term distributions made, and no one's actually going to look at that until it becomes a problem. And the issue then becomes, once somebody does, uncover this issue, you're going to have to claw back, and you're going to have to basically pass 20 to 30 years worth of updated tax returns. And I mean, it'd be interesting to see how the ATO would deal with a beneficiary who has to pass updated tax returns and sort of say, well, look, I thought I was receiving these valid distributions from the trust. I've actually been told that they weren't. And then it's this issue if the trustee's personally liable, and it can cause problems, particularly because, unfortunately, a lot of firms will charge a set fee to vary trusts. They use a precedent that is designed for a one-size-fits-all, but it might not actually fit with the exact wording and scope of the variation powers within the particular trust deed. But on that point, if there is a willingness from the family, particularly the next generation who are starting to come in and control these trusts, if they do want to vary the trust in a way that is contrary or potentially outside the powers of the variation clause in the trust deed, what options do they have?
It's an interesting one, because we always start with the terms of the deed and we look at the variation power. When you're in a situation where the variation power doesn't permit what is intended, so for example, it's a very narrow variation power and you can't do what you propose to do, you're not necessarily stuck, but the pathway does get more convoluted. And when I say more convoluted, in certain instances where you've got a small class of beneficiaries, you can potentially get the consent of all of those beneficiaries, provided they're adults and they have capacity to actually authorise the trustee to take a certain step. Now, the practical reality is that with most of our discretionary trust deeds in Australia, the class is so broad, you have unborn persons, you have minors, that you can't get those consents. So that then pushes you into looking at, well, what processes are there under the relevant trustee acts or trust acts, depending on your jurisdiction. And the courts in most of those jurisdictions do have the power to actually approve an arrangement on behalf of beneficiaries who can't give their consent, where the court believes certain requirements are met in relation to those arrangements and the giving of that consent. So in Victoria, for example, that's under Section 63A of the Trustee Act. And there's been a number of cases recently where trustees had limited variation powers or had no variation power at all, and the courts were asked to consider certain arrangements, and then after appropriate consideration and the courts becoming comfortable with what was proposed, they were then able to make orders and declarations in relation to the trusts being varied to give effect to those arrangements.
I mean, have you, in your experience, and obviously you've been doing this a lot longer than me, is it common to see a trust with no variation powers, and with respect to those trusts that don't have variation powers, sort of, and if you've ever been asked to draft a trust deed in that way, what would be the thinking behind that?
We don't see many of them, thankfully. I couldn't say why you wouldn't include a variation power in a trust deed. It gives a lot of flexibility. It gives the ability to update the deed and to keep it current with current changes in legislation. If you look at recent changes that have been brought about because of the Tax Act or because of foreign beneficiary exclusions and duty surcharges, if you don't have a variation power, you're very much going to be in the back seat trying to deal with those types of issues. So unless a client's very, very specific that they want to hardwire the terms of the trust and they don't want to give any power to do certain things, you should generally have a broadly drafted variation power. Otherwise, you sort of fall back, as I say, into that situation where you do need to go to the court. And as soon as you're stepping into the court, that's a Supreme Court process. There's a lot of expense, there's a lot of time, and there's a lot of work that goes into those applications. And we're running a number of those applications at the moment. And ultimately, if they're successful, they would give a significant benefit to the beneficiaries of those trusts. But it is not a lay down misere, so to speak.
No.
You do really have to convince the court that this arrangement is for the benefit of the relevant people. That's sort of the first stage of that test. And then provided the court's satisfied with that first stage, the court then has to consider if that's a proper and a fair arrangement for the beneficiaries as a whole. And if they're satisfied with that, you then have a chance of the court saying, okay, we are going to approve this on behalf of those people who cannot consent to it themselves.
And it's an expensive, time-consuming process. The beneficiaries have the right to be heard, so they get independent representation. There can often be cost orders involved that basically the trust potentially bears the entire cost bill. And it really goes back to what we see in this area quite frequently, in that to actually have these family trusts set up is quite a minimal cost. A lot of people go to their accountant and get a standard precedent done, and they don't really take much advice about the terms of the trustee, what it means to be appointed in particular office holders and positions within the trust. But if there's not actually some thought about what the trust is trying to do, the issues that that person and that their family might face in the future, you end up getting to a point where there's significant hurdles that have to be gone through and jumped over to actually sort of remold the trust in such a way that it's going to be fit for purpose of future generations. And the cost that, as you've just gone through, having to make an application to the court compared to just actually spending a bit of time with a proper advisor, getting good legal advice at the outset when the trust deed is drafted, it's 10, 20, 30 times, if not more. But people don't see sometimes the benefit of that until it becomes a problem.
It's often understandable because when a lot of these structures are set up, people are in a rush. They want to get things done so that they can get that deal, or they can buy that property, or they can do these things. But if you've got the time to actually give it some consideration, to talk through beneficiaries, to talk through the powers in the trustee, to talk through and understand what the potential issues are, and a lot of that we'll talk through in this podcast series, you can, to your point, really take quite a broad set of risks and really reduce those risks or completely extinguish those risks in some cases. And it really does go back to the point about, if you can prepare for these properly and you can draft them properly and you've got the time to consider it, it does make a big difference in terms of how well they work in the future and avoiding those issues that we see on a far too regular basis.
So obviously a lot of these trusts are designed to hold assets, for the benefit of those who create the trust, but also for future generations who may benefit. Are there any tax issues that can arise in terms of the way you try to vary these trusts, or is there full scope to effectively be able to vary all aspects of the trust as much as you'd like?
With trusts that do hold assets, it's really important to look at what we're doing and really look at the breadth of that variation. Thankfully, the ATO has guidance in their tax determination 2012/21, which has been around for quite a few years now. And that gives a really good overview of what the ATO's position is in relation to CGT events E1 and E2, which are commonly referred to as resettlements of a trust, but it is a specific tax provision there. And what that really says is, look, if you are exercising a variation power under the terms of the trust deed and you're doing that properly, or if you have the order of a court to vary the terms of the trust, that variation is generally okay and it doesn't cause a CGT event. But it does also point out that if you make significant changes to the terms of the trust, and it talks about a charter of rights and obligations, so a situation where you're really changing some of the fundamental aspects of the trust, that's where you get into a more problematic situation, and that's where you can potentially cause those CGT issues to come about. And that's something that we generally don't want with a trust, because as I said earlier, a lot of these trusts were set up in the 1970s and 1980s, and they've been holding real property for many, many years, and that's gone up significantly in value. So if that's post-CGT property and you resettle the trust, you're going to have a significant CGT issue, and you're probably going to have a stamp duty issue as well for what it's worth. The revenue authorities aren't quite as generous with their guidance in some jurisdictions about what constitutes a resettlement. But generally, if it's going to tip over the edge from a CGT perspective, it's probably going to tip over the edge from a duties perspective as well.
So the key takeaway is, if the trust has been holding assets for a long period of time and you're considering making some substantial changes, you need to get proper advice about the effect that may have.
That's right. So that again goes back to that preparation point, getting it looked at properly, making sure the power is exercised properly, because that tax determination is premised on the powers being exercised properly. So again, if it's an invalid exercise, you're potentially falling foul of that TD, and really making sure that it's looked at before it's done properly. Well, that's a nice way to round out our discussion about trust variation. So just to close that out, really good reminder to look at the terms of the trust deed to really understand what that variation power allows you to do or not to do. Make sure that you're following and complying with any of those specific requirements, such as consents of appointors or guardians, and then also considering that tax point, because the last thing we want to do is trigger a CGT event or a duty event. Next episode, we will be looking at trustees and exercise of discretion, and what you should and shouldn't be doing when you are a trustee. Thanks for listening, and we look forward to speaking to you again next week.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.